welcome to our series, Simply Multifamily. My name is Kiran Dhillon. I am a broker-associate with KW Commercial, specializing in multifamily sales. The purpose of this series is to highlight issues that affect owners of multifamily properties via market updates, investment insights, and interviews with trusted professionals. Today, we have the privilege of sitting down with attorney Anthony Marinaccio of Marinaccio Law regarding some of the new 2022 laws relating to real estate that affect landlords and owners of multifamily properties. Welcome back, Anthony. Thanks for being here.
Hi, Karen. Nice to be here. And thank you for having me.
Of course. The first law I'd like to talk about is SB 567 and the changes to the Tenant Protection Act, aka AB 1482. So it's my understanding that there have been updates to both the rent cap provision and the no-fault eviction provisions. Is that correct?
That is correct. So as many landlords know, under the statewide law, there's a cap every year that you can raise rents. Currently, it's 8.8%. And however, prior to this year, there was no enforcement mechanism. And now the law has changed slightly, well, dramatically, in the sense that if you as a landlord illegally raise the rent more than what you should have, a tenant can seek that money back and possibly even treble damages, which would be 3 times that amount. For landlords that may have buildings in the city of LA that are aware of this, they might be aware of this law already, but now it's just statewide. So particularly when if you did an illegal rent increase that was large, that was illegal in the last few years, you may want to have to recalculate the numbers and give the money back now, as opposed to waiting later.
That makes sense. And is there any distinction between landlords who were unaware and accidentally raised it too much versus landlords who did it kind of willfully?
No, so unfortunately, lack of knowledge of the law is not a defense. So unfortunately, that means that even if you did not know about it and you later find out, you could be liable, which means that you should make sure that you're compliant now, especially. And so, for example, like I said, this year it would be 8.8%, and it's recalculated every July 1st.
And when does this law take into effect?
That was in effect January 1st. Oh, I'm sorry, April 1st of 2024.
Okay, so people have a little bit of time to figure
that out,
right? If their increases were too high, and kind of correct that.
Correct.
Okay, and then what about the changes to the no-fault eviction provisions?
So there were 2 in particular for most landlords. The 2 areas that were no-fault evictions that were pretty common were the owner move-in and also the substantial remodel. Under the owner move-in, it clarified the law that the law now requires, or will as of April 1st, it will require certain notices, be adding language to certain notices, and we'll talk about that after we're done. But now the owner or the occupant that's supposed to move in has to move in within 90 days of the move out, and also has to live there for at least 1 year. Also, unlike before, if the owner you can't switch units. So if the owner lives in one unit, the owner cannot now move to another unit in the building. And if there is a vacant unit that is vacant, that's similar to the one that you want, that one you would have to use the vacant unit. You can't evict that tenant then.
Okay.
Now, if, for example, an owner moves in and they only live there for 6 months, they may have to give back the unit back to the tenant that they evicted or that they had moved out, and they would have to give it to them for the same price that they were paying. They may also have to reimburse the expenses that the tenant had in order to move out, which can be substantial. It's also important that the notices for the owner occupancy do include certain language in the notices themselves regarding the move out and regarding moving back in and the relocation. So it's always very important that if you're doing your own notices, that you make sure that you use the most relevant and timely notices. I know a lot of people use old ones that are from years ago, and then we can't use them because they're invalid, and that would be a very good defense if they have to go to court. And now for the second type of eviction that was very common, which actually was very common, was known as a substantial remodel. And
Yeah.
under the substantial remodel provision, now it requires that the remodel be substantial enough that it would require the tenant to be out of the unit for more than 30 days. I generally think that that means it has to be to the building itself,
Mhm.
electrical, plumbing. It cannot be, for example, repainting the building or changing carpets or changing the flooring. It has to be substantial, and it also has to require a permit. So now when you do the notice, when you do serve the notice, you would need to make sure you have a copy of the permit. And so obtain those permits beforehand. And also you need to have some sort of description in the notice of the type of remodeling you intend to do, including some sort of schedule or plan that's required. There's also further notice provisions that are required in there regarding if the tenant wants to move back into the unit and to provide new addresses. So that's important, again, to make sure you have the right notice in that as well. And it's also important to have that plan and actually execute that plan once the tenant moves out. So for example, I've seen a lot of larger models, meaning, kitchens, moving walls, bathrooms that are substantial altogether. I've also seen some that involve the whole building where you're, redoing the piping in the whole building or electrical work or something like that, combined with other remodeling would get to that substantial remodel provision. It's also important for both of these that the new laws now actually have an enforcement mechanism, meaning that, for example, if a landlord says they're going to move into the unit, or if they say their grandmother is going to move into the unit, that they actually move into the unit. And if they don't, or if you don't do the remodeling that you had said you were going to do, the tenant could file a lawsuit for fraud and also for damages under this particular law for their out-of-pocket damages and multiply that by 3, which can be substantial.
Right.
I know I've seen some claims of moving that could cost $10,000 to $15,000 at a minimum I've seen. So it's multiply that with other damages and it can get pretty high. It's also important to note that for landlords in LA County, this only applies to incorporated cities that do not have stricter rent control laws. So for example, right now, City of Los Angeles, West Hollywood, Santa Monica, Pasadena, in this area, all have stricter rent control laws, or eviction control laws, I should say, stronger than the statewide limit, and also unincorporated LA County. So if you're in those areas, you actually have to follow what's in the city laws or the local rules, as opposed to the state law. If you're outside of LA County, most cities have not enacted their own rent control laws. So Orange County, Riverside, and San Bernardino, I think only a few cities have so far. But LA, they've quite a few new cities have already enacted some. I believe Burbank has done some a little bit. Pomona recently had one. I think they just passed. So it's getting more common. So you should check that to make sure, even if you've been doing business a long time in that city, they may have changed the laws. The other big law for this year that's changing is security deposits.
Oh, I wanted to ask you one quick thing before
Oh,
we
yeah.
do that. The notices for the owner move-in and the substantial remodel, how much time ahead of time do you have to give those?
At least 60 days in advance. Those have to be done at least 60 days in advance. You can always give more time, but you can't give less.
Okay.
And it's really important that you use the proper notice.
Right.
I'm seeing that a lot with 3-day notices, and I'm seeing that a lot with 60-day notices right now, that people are using the same one that they found online from 10 years ago, and they're just not valid anymore. So just make sure you do the right notice. And now are you ready to talk about security deposits?
Yeah. And we can talk about security deposits. Yeah.
Perfect. And so the laws change in July 1st, 2024. A landlord cannot, will not be able, I'm sorry. Current law says that you can rent up to you can actually charge 2 months security deposit or for an unfurnished unit, up to 3 months for a furnished unit. The new law as of July 1st of this year will say that you could only charge 1 month's rent as a security deposit. And let me just make sure I confirm this. And I'm sorry, just 1 month's rent. That's also important. Make sure, because those are, if the ad is incorrect, you could get calls from the fair housing or people looking to start lawsuits for something as silly as, charging more security deposit. There is an exception if an individual owns less than 4 units combined. That's pretty rare, but if you do have that, you could charge more, except for the person is a service member, if the tenant is a service member. If they're an active duty service, then it goes back to 1 month.
Got it. So if somebody owns a duplex and a triplex, and it's 5 units together, then that exception doesn't apply to them.
Correct. So any landlord, so for example, if you are an individual landlord and you have a back house, you can charge the higher amount, and that if that's all you own. But as soon as you own more than 2 buildings, or if you own 2 buildings and more than 4 units, automatically you're going to be under that 1 month restriction.
Okay.
Also important, although state law, I don't know of a city that changes that aspect of the law. A lot of local cities do have security deposit interest rates that might be charged. So it's always important to know, if you're in a city that does have rent control laws, there might be a charge for the interest for the security deposit.
Okay. And when does this security deposit law go into effect?
That would be July 1st, 2024.
So if you are a landlord and you already have a lease and you collected, the 2 months or 3 months under the prior law, do you have to give it back?
You don't have to return it. You just have to now, starting July 1st, any current lease has to only have that 1 month.
Okay. So landlords have until the end of June, essentially, if they're renting out a unit, to collect under that old scale of 2 or 3 months.
Exactly. Correct.
Okay. Got it. Excellent. Well, that pretty much wraps up our discussion for today, Anthony. Thank you so much. There are a lot of new laws in 2024 relating to real estate and multifamily owners and landlords, but we wanted to keep it brief and get this information out. And then if people have questions about, other laws that they've heard about, feel free to reach out to me. You can reach out to me at my email, Kiran@sigcommercial.com. And Anthony, I'm sure you're open to people reaching out to you with questions as well.
Sure, you can always call my office or email me if there are specific questions you have or notices that you'd like to serve.
Okay. And what's your office number?
My office number is 818-839-5220.
Great. And I would highly recommend, if anybody is in the process or planning to serve these notices, to reach out to Anthony, because you do want to make sure you're doing it correctly, because if it's done incorrectly, not only is it invalid, but you could be on the hook for quite a bit of damages starting here.
And the most important thing about the notice is make sure they're done correctly when you serve them, because if you wait 60 days and then you have me look at it, what you don't want to hear is me to tell you they're wrong, start all over again. And then you have to start those 60 days all over again. There's no way to correct a bad notice unless you just accept to serve a new notice.
Okay.
So it's always important to do it correctly the first time, and or have an attorney look at it when you first serve the notices, as opposed to waiting if the tenant doesn't move out and then having to show the notice to somebody.
Right. So do it correctly the first time.
Correct, the first time. Otherwise you're gonna be stuck waiting longer.
Right. Do it right or do it twice, right?
That's right. That's right.
All right. Thank you, Anthony.